If you don't listen closely to what I'm about to tell you, you may kill your work comp case. In this video, you'll learn the top 10 mistakes that injured workers make that completely destroy their work comp case and how you can stop that from ever happening. How's it going? Domenic Celeste, the virtual accident attorney here, and I'm back with another video. For those that don't know, I represent people injured on the job in workers' compensation and due to the fault of another in personal injury all throughout Florida. Now, as usual, before we get started, I have to show you this disclaimer, so just hold tight. And with that out of the way, let's get into the video. Before we begin, a mistake in a work comp case is something that has a negative impact on it that would have been completely preventable if the injured worker was informed of the consequences of their action or inaction. In other words, it's something that stops you from getting benefits all because you didn't know any better. I'll put out another video in the future going over the less important mistakes that won't kill your case but may make it more difficult or worse off. And with that, let's get into the worst mistakes that you can make that may kill your work comp case, starting with number 10 and working our way down to number 1. The number 10 mistake is not reporting your accident as being work-related or giving the same description of the accident. First, if you get hurt at work, you need to tell anyone who asks that it happened at work. This includes your employer, coworkers, doctors, friends, anyone who might eventually be asked by work comp about how you got hurt. And if you don't, and say it was something not work-related, later on, when you try and change your tune, no one, and most importantly, the judge, won't believe you. And if the judge doesn't believe you, you lose. Sometimes your employer tells you not to report it as work-related and that it will take care of everything itself, but don't believe them. They're just setting you up for failure. Little tip here is to never trust your employer when it comes to your work comp case. Also, even if you do report your accident as being work-related, you need to make sure that you keep your story straight and say the exact same description to every person. This is important because if your story changes even just a little bit, it diminishes your credibility with the judge, who will most likely believe the employer over you if it comes to it. The number 9 mistake is seeing your own personal doctor. Medical evidence is what drives a work comp case. The only medical evidence that's admissible in a work comp case, though, are opinions from authorized doctors, independent medical examiners or IMEs, which are either your work comps experts or an expert medical examiner or EMA, which is the judge's expert. So if you see your own doctor, that doctor's opinions will never be allowed in front of the judge. And if you don't have medical evidence to support your case or your claim for medical care or lost wages, then you lose and get nothing. Also, work comp is only responsible for paying for medical care that's recommended by an authorized doctor, IME, or EMA, which means your personal doctor's bills will be your responsibility to pay, not work comp's. Further, if you try and use your own health insurance and they find out your injuries are work-related, they may deny payment, leaving you on the hook for the bills to pay out of your own pocket. The number 8 mistake is not paying your taxes. You might be wondering, why does this even matter? Well, it matters because your average weekly wage is calculated based on the money you made on which you pay taxes. If you didn't file your taxes, then there's no money to use as a value to calculate your average weekly wage, which means you don't get paid anything. Now, even if you haven't paid your taxes yet, you still can even after your accident. And once that's done, then your average weekly wage will be calculated and you'll be paid. However, you won't get any penalties and interest during that time that you were entitled to lost wages but didn't pay your taxes. The number 7 mistake is not filling out the Employer Earnings Report or EER forms, which are also called DWC-19s. EER forms show what, if any, other income you're making besides work comp checks. The purpose of these forms is so that work comp knows how to pay you correctly, since if you're making other income, there may be an offset with work comp, meaning work comp can pay you less depending on what other income you're making. The reason filling these forms out is important to you is because if you don't, work comp can deny paying you lost wages. Also, until you do fill them out and send them to work comp, you won't get paid penalties and interest on the late payments. However, work comp is responsible for sending you these forms to fill out. So if they don't and the delay is due to work comp not sending you the forms, penalties and interest will be added to your payments. The number 6 mistake is not returning to work or quitting your job. This relates to entitlement to lost wages or work comp checks, which is called indemnity or disability benefits in work comp. To get work comp checks, your work comp doctor needs to have you out of work or on at least work restrictions, and not at max medical improvement or MMI. Once this happens, it's on your employer to offer you a light duty job in writing. Otherwise, work comp will have to pay you about 2/3 your average weekly wage. However, if you don't at least attempt the job that is offered, work comp can deny payment of work comp checks due to something called voluntary limitation of income, which also applies if you quit your job. Voluntary limitation of income basically means that you're the reason you're not making a wage, not your work injury. So if you're offered a job, even if it appears that it may be outside your work restrictions, still attempt it. And if it's outside of your restrictions, report that to your employer and your work comp doctor so that you have evidence that your refusal of this light duty job is justified. Also, rather than quitting, wait to be terminated, because then it's impossible for work comp to offer you a light duty job, and it might set up another case for work comp retaliation. If you're forced to quit, you better have some good evidence that you had no choice. Otherwise, your lost wage claim will be denied. The number 5 mistake is missing court-ordered events. There are certain events such as mediations and final hearings, which is what court is called in work comp, that are scheduled by the court. If you miss these events, it could mean the end of your case depending on the circumstances. If you miss mediation, then the judge will give you the opportunity to explain why at a show cause hearing. But if your excuse isn't good enough, then your claims will be dismissed without prejudice, meaning you can refile them again, but only once more before any subsequent dismissals are with prejudice, which means you can never file them again. If you miss the final hearing, you don't get an opportunity to explain. Rather, the claims you brought to court will be dismissed with prejudice, meaning you're done requesting those exact benefits again. Basically, just don't miss these events. The number 4 mistake is refusing authorized medical care. Firstly, you have to see your work comp doctor at least once a year, or your case will be closed due to violation of the statute of limitations. Secondly, if you don't get the medical care that your authorized doctor recommends, work comp can deny your case for medical noncompliance. If there comes a time when your work comp doctor recommends something that you don't feel comfortable getting, like for example surgery, then it may be a good time to settle your case. For more information on settling your case, check out the video linked in the card above. The number 3 mistake is not reporting your accident and injury within 30 days of it occurring, or when you knew or should have known that your injury was related to your work. This is the first requirement that you have whenever you get hurt at work. If you don't do this, your case is over before it even started. There are some circumstances when you might be able to get around it, but in most cases, this will be the death of your case. I'd recommend that you always report your accident and injury immediately to a supervisor and in writing, such as an email or text. The sooner you report, the better the chance that work comp won't deny your case. If it's in writing, then you have evidence in case your employer lies and says that you didn't report timely. The number 2 mistake is not filing a work comp claim within 2 years of your accident. This is called the statute of limitations. This mistake never really comes up if you have an attorney, but if you don't, even if you have a case, you still have to file a claim. Sometimes there are things that toll or extend the date by which you have to file a claim, but it's important to note because if a claim isn't filed timely, then your case will be over. You can bet work comp is keeping a close eye on this end date, so you should be too. I always file a claim as soon as I come on a case, as well as multiple times throughout the case, which keeps extending the end date so we never get into trouble. And lastly, the number 1 mistake is exaggerating or not telling the truth. The easiest way for work comp to deny your case is if you exaggerate or don't tell the truth and they find out, because then they can deny your case for fraud, which is called misrepresentation in the work comp statute. This is where work comp will present you to the judge as a liar, and if the judge agrees, your case will be dismissed. What's crazy is that the misrepresentation doesn't even have to be relevant to your case. It can be about anything if there's even a slight chance that the judge will believe it was for the purpose of securing work comp benefits. The most common examples that I've seen are where you don't tell a doctor or the work comp attorney in deposition about a prior injury, or when you say you can't do something, but what you really mean is that you have pain and limitations, and then they catch you doing it. I always tell my clients that it's easier to get around a truth than it is a lie, and you need to understand that as well. Also, always assume that work comp is watching you, because chances are they've probably hired an investigator to follow you, especially if your case is valuable. Now for the bonus mistake: not hiring an attorney to help with your work comp case. Florida workers' compensation laws are very complicated, too complicated to handle on your own, and are constantly changing too. Trying to handle your case yourself is only setting you up for failure, because not only do you not know the extent of what you can get, but you don't know what it takes to get it. Too often the injured workers come to me for help after something goes wrong or something is delayed when they wouldn't be in that position if they just hired me in the first place. And there's literally no reason not to hire an attorney since their representation is completely free and you don't pay a dime unless you settle your case. It's like having insurance without the copay, and who doesn't want that? Hiring an attorney is protection for you in your case and will most likely stop you from making any of the other top 10 mistakes that I just talked about that may kill your work comp case. So in summary, report your accident as work-related and always give the same description of accident. Don't see your own doctor for your work comp injury. Pay your taxes, fill out the EER forms, attempt light duty and don't quit your job, attend court-ordered events, see your work comp doctor at least once per year and get the medical care recommended by the authorized doctor or settle instead, report your accident and injury within 30 days of it occurring, file a claim within 2 years of your accident, always tell the truth and don't exaggerate, and hire an attorney. And there you have it. Now you know the top 10 mistakes that injured workers make and what you can do to prevent them. If you or someone you know were injured on the job or due to the fault of another, you need to hire an attorney. Give me a call any time of the day or night. I have a 24/7, 365 receptionist, or better yet, you can just text me, 561-935-3822. But that's it for this video. If you got value out of it or if you learned something, please hit that like and subscribe button. To learn more, watch my previous video here or watch a video I've chosen for you here. Again, I'm Domenic Celeste, the virtual accident attorney. Thanks for watching, and I'll see you in the next video.